Case 14. Sikkelee versus Precision Airmotive Corp. We find ourselves in the U.S. Court of Appeals once again for the Third Circuit. Here are the facts. This case involves alleged manufacturing and design defects in a Textron Lycoming 0320 engine, manufactured in 1969 and installed factory new on a Cessna 172N aircraft in 1998. Lycoming holds both a type certificate and production certificate for the engine. The engine in the aircraft was overhauled in 2004 and installed with a specific carburetor in accordance with Lycoming's type certificated design. David Sikkelee was piloting the aircraft when it crashed shortly after taking off from Transylvania County Airport in Brevard, North Carolina, in July 2005. Sikkelee was killed as a result of serious injuries and burns he suffered in the crash. His wife, Jill Sikkelee, the plaintiff appellant in this case, alleges that the aircraft lost power and crashed as a result of a malfunction or defect in the engine's carburetor. Specifically, she contends that due to the faulty design of the lock tab washers as well as gasket set, vibrations from the engine loosened screws holding the carburetor's throttle body to its float bowl. When properly functioning, a carburetor regulates the mixture of fuel and air that enters the engine's cylinders. According to Sikkelee, however, the manner by which the throttle body was attached to the float bowl in this engine allowed raw fuel to leak out of the carburetor into the engine and thereby caused the aircraft to crash. Sikkelee initially filed a wrongful death and survival action in the Middle District of Pennsylvania in 2007 against 17 defendants, asserting state law claims of strict liability, breach of warranty, negligence, misrepresentation, and concert of action. In 2010, the district court granted defendants' motion for judgment on the pleadings, holding that Sikkelee's state law claims, which were premised on state law standards of care, fell within the preempted field of air safety described in Abdullah. Sikkelee subsequently filed an amended complaint, continuing to assert state law claims, but this time incorporating federal standards of care by alleging violations of numerous FAA regulations. So what's the issue in front of this court? Whether Abdullah, in which the court held that federal law preempts the field of aviation safety, extends to state law products liability claims. The court held that it does not. They reversed the district court's entry of summary judgment in favor of appellees and remanded for further proceedings. Let's look at the reasoning behind this holding. Considering principles of federalism and the presumption against preemption, Congress must express its clear and manifest intent to preempt an entire field of state law. In this case, none of the relevant statutes or regulations signals such an intent. To the contrary, the Federal Aviation Act, the General Aviation Revitalization Act of 1994, and the regulations promulgated by the FAA reflect that Congress did not intend to preempt aircraft products liability claims in a categorical way. The district court faithfully sought to apply the precedent, and while it concluded that state products liability claims are preempted by Abdullah, it also recognized the question was sufficiently unclear and important to certify its order for interlocutory review. This case clarifies the scope of Abdullah and holds that neither the Act nor the issuance of a type certificate per se preempts all aircraft design and manufacturing claims. Rather, subject to traditional principles of conflict preemption, including in connection with the specifications expressly set forth in a given type certificate, aircraft products liability cases like appellants may proceed using a state standard of care. At its core, Sikkelee stands for a straightforward plaintiff-friendly proposition. The holding in Abdullah that federal law preempts the field of aviation safety does not extend to state law products liability claims. In other words, plaintiffs can bring a state law products liability claim and it will survive a motion to dismiss on preemption grounds. The Federal Aviation Act, the General Aviation Revitalization Act of 1994, and the regulations promulgated by the Federal Aviation Administration reflect that Congress did not intend to preempt aircraft products liability claims in a categorical way. Let's discuss the scope of field preemption under the Federal Aviation Act of 1958. More specifically, whether the preempted field includes torts claims based on alleged defective design or manufacturing. The Federal Aviation Act contains a savings clause, which provides that a remedy under this part is in addition to any other remedies provided by law. The Supreme Court observed that this statutory scheme permits states to retain their traditional regulatory power over aspects of aviation, while the inclusion of the savings clause is not inconsistent with the requirement that courts apply federal standards of care when adjudicating state law claims. It does not show Congress demonstrated a clear and manifest intent to preempt state law products liability claims altogether. The Court concluded that the Federal Aviation Act and its implementing regulations did not indicate a clear and manifest congressional intent to preempt state law products liability claims. Congress has not created a federal standard of care for persons injured by defective airplanes, and the type certification process could not as a categorical matter displace the need for compliance in this context with state standards of care. The Court held that neither the Federal Aviation Act nor the issuance of a type certificate preempted all aircraft design and manufacturing claims. Rather, subject to traditional principles of conflict preemption, including in connection with the specifications expressly set forth in a given type certificate, aircraft products liability cases could proceed using a state standard of care. For these reasons, the Court reversed the District Court's entry of summary judgment in favor of the appellee and remanded for further proceedings.